this is Lynn Barco with the Minnesota Alliance for Ethical Healthcare. Welcome to our today's webinar, part of a series of webinars that the Alliance is supporting involving coalition members, policy advocates, and healthcare professionals. I want today first to talk about the Alliance itself and all of the great coalition partners that make us so strong. In particular, I want to thank several recent coalition members that have just joined us here. We have the Metropolitan Center for Independent Living, the Military Order of Purple Heart Department of Minnesota, and Wounded Warriors United here in Minnesota as well. And adding new partners is a really important part of the work that we do. So I want to make just a short pitch before we get into our main event. The Alliance is really only as strong and effective as the breadth of the partners that join us. And so I want to show a slide here just so everyone can see how you can invite organizations that might be in your network to join the Alliance. You can see the link right there, ethicalcaremn.org/join us. This is a great way to bring those partner organizations into the work that we're doing, promoting compassionate alternatives to the legalization of assisted suicide. To get started as an Alliance partner, there's no cost, and their name of the organization is listed with our 75, we're now up to 75, we'll have to update our slide, partners with the organization. So we are growing, and our goal is to reach 100 partners by the end of this year, and I'm really confident that we can do it with your help. We'll also send out this link after the presentation so that you can share it with everyone in your network. Also want to say too that today's presentation will be recorded and will be available on the Alliance's YouTube channel. And you can look at that again if you'd like, or again, share it with those in your network. So on to our main event today. Very pleased to be hosting Dr. Annette Hanson. She will be speaking about assisted suicide laws, implications for state institutions and their patients, a really interesting topic that I think we're going to learn a lot about today. Dr. Hanson will address the legal basis for these concerns and how familiarity with this information can inform advocacy efforts. Attendees today will learn how assisted suicide laws complicate the practice of psychiatry, and will learn relevant talking points that can be persuasive in discussions with mental health care professionals. Annette Hanson, MD, is the director of the Forensic Psychiatry Fellowship at the University of Maryland and co-chair of the Maryland Psychiatric Society's Legislative Committee, where she has reviewed legislation related to assisted suicide and testified on the issue in the state's legislature. She has 30 years of experience in the provision of psychiatric care to patients in Maryland's Division of Correction and state hospital system. And she's also has roots in Minnesota. So welcome back home, Dr. Hanson, and I will hand it over to you for about 20 minutes or so, and then we will do questions, and you can enter your questions in the Q&A function at the bottom of your screen. Welcome, Dr. Hanson.
Thank you so much. It's great sort of virtually being back in my home state. And I greatly welcome the opportunity to talk about this topic. I'm going to be discussing an aspect of this policy that almost never gets spoken about in legislatures when they're considering these bills. I'm going to first give my usual disclaimer that the views I'm expressing today are not the views of any of my affiliated academic institutions, nor of the professional organizations I'm involved in, with the exception of the American Medical Association and the American Psychiatric Association, both of which consider the practice to be unethical. I'm speaking today specifically about state facilities, in other words, prison systems and state psychiatric hospitals. And I'm talking about this because this is an aspect of vulnerable people that are at high risk and are rarely considered when legislatures are debating the bills. State psychiatric hospitals today mostly contain forensic patients. And when I say forensic, what I mean is that these are people with serious mental illnesses who are charged with crimes and may be too mentally ill to go to trial. So they are considered incompetent to stand trial, or IST. They also include insanity acquittees. In other words, people who have committed offenses, but because of their mental illnesses, they're not punished or sentenced to prison. They're confined to a psychiatric hospital for treatment instead. This is relevant because the lengths of stay are tremendous. Okay, so you could have an individual charged with a misdemeanor offense, but they're confined not the length of a sentence, but for however long it takes them to get well enough to be released to society. The average length of stay in the typical psychiatric hospital now is measured in days. For forensic patients, the length of admission is measured in years. It could be 5 years, it could be longer. It just depends on how long they require for treatment. Now, I've included sex offender commitment facilities in this. They're not truly psychiatric hospitals. They're a very unique institution in some states where they have sex offender commitment laws. So these are states where a sex offender may have completed their time in prison, but because of their sexual disorder, they're considered too dangerous to be released to the community. And so they're committed instead indefinitely for treatment in a state facility. And then in prisons, of course, now we have what's called the problem of the elderly prisoner. And I always cringe a little bit when I say this, but in prisons, elderly is considered to be over age 55. And there's a good reason for that, because in prison, our people that we treat tend to be poor, they tend to lack social supports, they don't get routine medical care, and so they come into the facility and the system very sick. Now, nowadays, the proportion of prisoners who are considered elderly are actually higher than the proportion of prisoners who are considered young. In other words, ages 25 to 35. And that's because of 3 strikes laws. That's because of life without parole sentences. So we have a large number of elderly people. A number of prison systems have created palliative care and hospice units to care for elderly prisoners with serious terminal illnesses. Now, 20 years ago, one of the most common causes of death in prison was suicide. And our great success story is once the Supreme Court required prisons to have mental health services, we've been able to cut that rate exponentially. So nowadays, the most common cause of death in prison is due to chronic medical conditions: diabetes, heart disease, dementia, cancer, AIDS. That makes up 90% of all prison deaths now. I'm sometimes accused of talking about scary, slippery slope hypotheticals, but this isn't a hypothetical problem. So we've already had examples of this in the US. So in 2017, there was one prisoner, he was physically healthy. His only condition was asthma, but he had elderly ailing parents. And so he on his own filed a motion with the court to be euthanized. He was serving life for felony murder. He wanted to be killed so that he could give his organs to his elderly parents. Now, fortunately, that motion was not successful. But again, people who are confined to institutions, they have access to the news. They watch the news. They can get newspapers. They can follow the Right to Die movement. And if it's okay for someone out in the community, why shouldn't it be okay for them? And as this example illustrates, he requested this euthanasia because of the Death with Dignity movement. In Canada, they have a constitutional right for assisted suicide or euthanasia, and 3 prisoners have already been killed through euthanasia in that country. And this is what the Inspector General found when they looked at these cases. They expressed concern about errors, omissions in following the law, inaccuracies in diagnosis, and misapplication of the policy. It's very concerning that the one case they picked out specifically was a nonviolent offender with a serious physical condition who was denied medical parole. He only had 2 years to serve. They didn't let him out, and he was given euthanasia instead of being released to a hospice program. This is one case that I'm personally familiar with. In 2019, after several years of effort, our bill finally got out of both committees. It passed the House. It was coming to a vote in the state Senate, and it was a highly publicized bill. And on the day that the Senate voted on it, one legislator didn't show up for the vote. It was a tie vote, which meant that the bill failed. It failed by one vote in our state that day. This got a lot of press coverage in the news, on the television, and on that particular day, one of our civilly committed patients requested lethal medication from his physician. And had that bill passed, we would have had a real serious dilemma, because he did have chronic medical conditions that could have been terminal if he had refused treatment. But at other times, he had a somatic delusion that he was terminally ill. So in other words, his psychosis expressed itself in the form of believing that he was dying even when he wasn't. And it would have been extraordinarily difficult to assess capacity in a case like that. Now, assisted suicide is different from all other medical interventions in spite of what the proponents say. Now, the proponents will say, oh, non-psychiatrist physicians assess capacity and consent to treatment all the time. We don't need to have mental health professional involved. We know how to do this, okay? But by law, there's a difference. By law, you don't just assess capacity. You also have to assess voluntariness or lack of coercion. And this becomes very difficult when you're talking about institutionalized patients. So there are a number of issues related to being in a state facility indefinitely that can lead to a decision to die. That's why we have mental health professionals there. So there's a coercive nature to the environment itself. I already mentioned the fellow who wanted to die rather than serve his time. At one point when our state had a death penalty, I evaluated essentially a capital defendant who was volunteering for execution. And that's exactly what he said. He said, if I had a choice between serving the rest of my life in a maximum security prison or being executed, I'll choose execution. That's what he did. That's what the state allowed him to do. And he was put to death. The other issue we have to deal with, especially in the older confined people, is the longer you're institutionalized, you lose your support system. Your elderly parents die, your children and siblings get married, move out of state, go on with their lives, they get divorced, and they lose that necessary support structure that keeps them going, and that's a problem. There's an inherent distrust of healthcare staff, and I see this regularly in my prison system, and I totally understand this. So that's an unspoken thought of, if you're willing to work in a place like this, you must not be very good. Okay, so it's hard for them to trust the medical advice given to them by healthcare professionals inside the institution. On occasions when my patient says to me, I'll explain their treatment options and the risk and benefits of the options, and then I'll say, what would you like to do? And on those occasions when the patient says to me, Doc, I trust you, do whatever you think is best, I am so humbled by that. I know what courage it takes to say that to a correctional physician. There are personal safety concerns. So I work in secure environments, a forensic hospital and a maximum security correctional facility, and these can be dangerous places. And if someone who is vulnerable, someone who has either a high profile offense or a sex offense, they're at risk for being assaulted. And there is that concern that if I'm going to get murdered by someone else, I might as well just hang it up. Okay, so personal safety concerns can lead to suicidal thoughts. Finally, prisoners do have a right to medical care, but they don't have a right to all medical care. And there are some medical interventions that are very expensive. They may be quasi-experimental, and it can be hard to obtain. When it comes to things like organ transplantation, prisoners are lower on the list for getting organs. That's just how the healthcare system works. And then finally, inadequate mental health services. And I'm going to come back to that point. Okay, in order to understand the problems that these policies create for doctors and healthcare professionals and institutions, it's important to understand the legal basis for why they get care and why are certain types of treatments mandatory. So I'm going to give you a very quick overview of correctional healthcare law. Okay. First of all, this is a federal law, the Civil Rights of Institutionalized Persons Act. Okay. This is the federal law that allows the Department of Justice to go inside psychiatric hospitals, nursing homes, juvenile facilities, prisons, and jails and investigate allegations of poor conditions of confinement, inadequate services, excessive use of force claims, every aspect of the institution, okay? And if there is a pattern or practice of violating rights based on the conditions of confinement, that's a very serious thing. For hospitals, you can lose your accreditation, you can lose all funding, and that's a problem. This is an interesting study that looked at the letters of deficiency that the Department of Justice mailed out to various correctional facilities over a number of years. This is the top 10 reasons why institutions are found in violation of civil rights. Don't ask me why they put the most common one at the bottom, but there it is. Failure to provide mental health care, failure to have adequate suicide prevention. That is a federal violation of civil rights in a state facility. You have an affirmative mandatory duty to prevent suicide in an institution. And then we also have a US Supreme Court case, Estelle v. Gamble. Estelle was the head of the Texas prison system. And in this particular case, the US Supreme Court said that a facility may not be deliberately indifferent to a serious medical need. This is what creates mandatory treatment guidelines. So if you accept assisted suicide as a legitimate medical intervention, if you consider it a legitimate intervention for a serious medical need, then you have to provide it. It would be a civil rights violation not to, okay? And so here we have two contradictory federal laws that says if you don't provide assisted suicide, then you're violating your right to treatment. If you do provide it, you're violating CRIPA for failing to prevent suicide. So you're damned if you do, and you're damned if you don't. That's why when I think about this stuff, this is my reaction. This is the kind of situation that drives healthcare professionals and institutions screaming into the night. So you're either violating the right for not doing it, you're violating it for providing it. It's a dilemma in federal law, and the states can't get around that because federal law preempts state laws. State cannot carve out these facilities and be consistent with the current federal standards. So how do states manage this? How do states get around this? I was very curious about this myself. So a few years ago, I started searching around when a smaller number of states had these laws, and I tried to contact the medical directors of all the state prison systems and the state hospital systems. And what I found was that the majority of states had no written policy on it at all. It just was not on their radar. They weren't thinking about it. I spoke to the medical director in the state of Washington, who has since retired. He told me that they really had a handful of requests in their prison system, but none of them had been granted. And he raised a very interesting point that I had not considered at all. Under all of these laws, the patient who gets the lethal medication has the right to decide when and where to take the medication, the time and place of consumption, okay? That's their right, whenever they want to do it, wherever they want to do it. Now, doctors are required to advise the patient not to take the medication in a public place. Well, how does that work in a prison or a psychiatric hospital? Okay? In a prison, that means if you have control over time and place, you have to give that lethal medication to the patient to keep on their person at all times for whenever they decide to take it. And they could take it anywhere. They could take it in an open tier in front of all the other prisoners. They could take it in the day area of a hospital inpatient unit in front of all the other patients. That would be their legal right. And just imagine what effect that would have on the psychological well-being of the people who witnessed that person's death. Think about how much that would undermine suicide prevention efforts in the state institution. Suicide contagion is a well-known phenomenon. That's why when there is a suicide death in a correctional facility, typically a lot of effort is put into calling down the other prisoners on the tier, checking in with them, making sure they're okay, making sure they know how to access mental health services if they need it after this horrible thing has happened on the tier. Now, California has dealt with this in a very interesting way, and I put the term interesting in quotes for a reason. Almost immediately after their law passed, they adopted emergency regulations, which they later finalized. So this is the California Code of Regulations, Title IX, CCR, Section 4601. And you don't have to read the whole thing. The relevant parts are: the Department of State Hospital shall facilitate the patient's access to participate in activities under the End of Life Option Act. And again, down in the second paragraph, hospitals will facilitate. So shall and will are legal terms of art. They are mandatory. That means under the health department regulations, you must provide suicide services in a state hospital. Now, imagine taking a facility that is designed specifically to prevent suicide, to keep patients safe from themselves. How is that going to affect the morale of the other patients on the unit? Imagine a unit where you have psychotic people who already have delusional beliefs that the doctor's medication recommended for treatment purposes may actually kill them. So you're reinforcing the delusional beliefs about someone's life-affirming healing medication when they know that the doctors also prescribe lethal medication. That's an issue. The more concerning thing is in the second paragraph. So if a patient in a psychiatric hospital is denied a lethal medication, they have a right to go to court and litigate the issue. And if a judge decides that person is qualified, a judge can cut an order mandating the hospital and the patient's treating physician to write lethal medication. So when you hear a proponent saying, oh, if you don't like it, you just don't have to participate, that's not true if you work in a state facility. In California, under the law, a judge can order you to do it. And if you don't comply with an order, you could be found in contempt. And a contempt of court could be either a civil fine or a criminal penalty. So this is a very, very high risk area for healthcare professionals working in state facilities. And look at the little part that I circled here at the end, on site. So if you can't find someone who will do it outside the facility, you have to help the patient kill himself within the hospital. Now, conversely, this is what the California prison system did. And this is really interesting because at the time their law passed and still exists today, the entire California prison system is under the Department of Justice court monitoring because of their lack of access to mental health services. So they took just the opposite approach. So their regulations say inmates in the custody of our prison system shall not be provided aid in dying services. So you have a prison system that's categorically opted out and a state psychiatric hospital that is mandated to participate. Now think about this. If you were a person who's confined, your liberty's been taken away, you have a serious mental illness and a serious physical illness, you either must be provided suicide or you are categorically denied suicide solely on the coincidence of where you happen to be housed. That is a definition of an equal protection problem, okay? Now, no one has challenged this yet. As soon as that prison regulation is challenged, it's going to fall because it's arbitrary and it's based solely on which system you happen to be housed in. But no one's challenged it yet because that's the end game of the right to die movement. Okay, I'm going to wind up here now with recommendations because I did promise to say, what do we do about this? So first of all, bring up the issue. So no one is talking about the federal laws and the implication of federal laws on the healthcare workers in state facilities. It's a hugely high risk area. And if it comes to a push coming to shove, our legislators are going to have to be aware that they will have to fund litigation, either pro or con, either to provide it or to prevent it. The state is going to have to provide the attorneys to argue these cases on appeal. We have to talk about the affirmative mandate to prevent suicide under federal law. States cannot override that. We have to do it. We also have to talk about the financial aspect because you can read their bubble thoughts. You know, legislators are thinking, well, you know, elderly prisoners, they're very expensive. They have all these medical bills. You know, it's a lot cheaper to do this. Well, no, okay, because I can tell you from experience, not a single state employee physician I've ever talked to about this or met would be willing to participate. And so if you're going to mandate that you do it, you're going to have to pay for outside physicians. You're going to have to pay for outside mental health consultants to do capacity evaluations. You're going to have to pay for the cost of medications. You're going to have to pay for the cost of litigation. Do you really want to step into that mess? Okay. And I would also, again, my disclaimer, I'm not a lawyer. I've read a lot about this, but I'm not a lawyer. I don't argue appellate cases. So I would encourage legislators to seek preliminary advice from their own counsel, from their Office of the Attorney General, to see how this would affect their state facilities. And with that, I have done this in exactly 20 minutes, and so I will take questions.
Thank you, Annette. Appreciate your presentation. I think that has raised a lot of interesting questions. I think my first question would be reflecting on the law that was recently reintroduced in Minnesota to legalize assisted suicide. It still has a provision in it that does not require a mental health evaluation. And even more worrisome, it introduces into the law physicians advising patients on the option of assisted suicide as a standard of care. So really radically re-altering the doctor-patient relationship, which I think is reflected and even magnified in what you said. So maybe can you talk a little bit about how these laws are really pernicious and designed to kind of radically change how people, whether they're in prison or outside of prison, receive healthcare?
Oh, that's a great question, because you raised the issue of informed consent and what does informed consent consist of. That was an issue in Vermont, where their Board of Physicians issued a preliminary opinion saying you have to advise them of all treatment options, including assisted suicide. So even if a patient didn't ask about it, you were required to give them that information. I can't think of anything worse from a psychological standpoint to be told about a serious terminal diagnosis and then immediately said, well, you can either do this and this, or you could kill yourself. What a horrible thing to do to a doctor-patient relationship. And the Board of Physicians then initially said, well, if you don't do it, it could be a licensure issue. So again, that's another legal risk for physicians in state institutions or in the system. And looking at the Minnesota law, it really strikes me how much these bills expanded. Every iteration of the bill in various states, and over time, they get looser and looser and looser. And now they're talking about allowing people other than physicians to prescribe. So they're talking about allowing nurse practitioners, physician assistants, people who don't routinely diagnose or treat serious terminal illnesses. And that's a concern in states where it's presently legal. Some of these doctors who set up end-of-life clinics, they're not neurologists, they're not oncologists, they may be anesthesiologists, they're not the people who routinely diagnose or treat these conditions. Now, the laws also say that the person who writes the medication has to be the attending physician of record. So in a psychiatric hospital, that would be a psychiatrist. Okay, you can't refer someone out to an anesthesiologist to write a lethal prescription because they're not the attending person of record, right? So the attending physician is the person who has ongoing responsibility for the patient's care, whether they take the medication or not. Okay, so if you send someone outside of an institution for a consult, that person then becomes the primary care provider, even if they're living in the facility. So how many consultants are going to be willing to take calls 24/7 whenever the patient has a problem, or come in every day and round on the patient? That's going to be an additional expense for the state. Under law, that's what they're supposed to be doing.
Thank you for that really interesting response. Your recommended actions appear to me to be compelling. This is a question from our Q&A.
Mm-hmm.
Has this approach enjoyed any success?
Yes. Okay. So working within the state system, it's important that whoever is in charge of the state system realizes the implications of what they're getting into, how it's going to affect their budget, how it's going to affect the staffing patterns, how it affects patient care, especially in psychiatric hospitals. Now, that aspect of advocacy doesn't get broadcast in the media because that happens behind the scenes, but it can be very effective. If you say, look, I saw this bill got dropped, run it up your chain of command saying, think about what this means for us. How are we going to practice if this passes? It also works if you're lucky enough. I mean, I was very fortunate in our legislature. We had some of our elected officials were physicians. And so they got it. They got it.
Thank you. I want to remind everyone that you can enter your questions or comments in the Q&A function at the bottom of the screen. We've already got some great questions here in the queue, but feel free to add more. Our next question relates to what you were talking about with state legislatures. My state legislators are strongly in favor of assisted suicide. When we visit them, they give us little time and have already made up their minds. How can we be effective advocates in opposition?
Oh, that's a great question. It really is a challenge. So when you testify in committee, you have 2, maybe 3 minutes to explain why doctors shouldn't be able to kill people. It can definitely be a challenge. So written testimony is good. In-person contact, it's really hard in the days of COVID, but show up in their offices, call them, write them, engage your friends. Snail mail, when the Postal Service works, document what the problems are, what your experiences are, and what the issues are.
I think that's great advice. I would also add that building that relationship with your legislator is really, really key. So the first time you meet with them and have a discussion, they may be reluctant or reticent or in opposition to you on the issue, but you have to keep going back with a lot of the information that we're talking about today. We also have a great one-pager that I will send out to all attendees on this call today of how we are advising our advocates to talk with state legislators about as well. And there's also, I think, a really important tagline that you can include in any conversation about this, that you can say that the rights of a few can ultimately harm or negatively impact healthcare for all of us. So I think that's exactly what Dr. Hanson is talking about today. We have another question here. New Jersey recently passed a law allowing assisted suicide influenced by lobbying on the side of proponents. And the question is, who pays for the lobbying? Well, I could say briefly, I'm somewhat familiar with that, and then I would have Dr. Hanson respond that the organization on the other side is pretty well funded, and they do have lobbying teams and others in various states doing this work. So just as we are advocating in our various states, the other side also has teams of people that are doing that as well. Do you want to say more about that interplay between lobbying groups and maybe how to navigate that nexus?
Yeah, well, that's another part of a talk that I gave in another session. Compassion and Choices is very creative. And when it comes to funding, I'm going to circle back to 2014 and the death of Brittany Maynard. So she became a figurehead. She was used as a marketing tool. She was young, she was attractive, she had a very heartbreaking story, and they designed an entire membership campaign around her death. They put up a website where you could go read her story and donate to the organization. And I read a news release by the company that designed this. And the day that she appeared on the cover of People magazine, their donation website got 100,000 hits per hour. It overwhelmed their server. They had to take the website down because it crashed. And so they're very effective about marketing to individuals. And then ironically, they say, okay, give us a donation, and then you can click another link and you can become a legacy member. In other words, you can will your estate to our organization. Wow, what a great gig. You can go to their website and look for a physician who prescribes lethal medication. Then you can go back and leave your estate to them. That's a pretty good gig if you can get it.
That leads into a next question, which you had mentioned about the suicide contagion. And I think some proponents say that that's a myth. It's not a reality. Do you want to talk more about the reality of the suicide contagion, both within state institutions, but also in society more broadly?
Yeah, it's very well established in the literature. This is a known quantity. We've known about it for the past 100 years. It's to the extent that the Centers for Disease Control has even developed media guidelines on how journalists should cover suicides in order to prevent copycat killings. You don't romanticize it. You don't emphasize the means of death. So one thing we've learned is that in the year after Brittany Maynard died, the number of people who died by lethal medication in Oregon jumped significantly immediately the year after. So publicity definitely affects these people.
Our next question begins with a statement that they're not sure if this particularly applies to state facilities, but perhaps you have an answer. Life insurance policies, if I understand them correctly, often have suicide exemption clauses. In other words, the insurance policy is null and void if a patient commits suicide. How do life insurance companies and even health insurance companies respond to physician-assisted suicide euthanasia attempts? Do they object, or do they pay out these policies when someone ends their life by those means?
Right. Well, that's an interesting aspect of the law. All of these boilerplate laws have an exception for insurance policies. They always have a section that specifically says, because this is not classified as a suicide death, it does not affect any life insurance. So they will still pay out. Okay. And whether or not they encourage it or not, because it's cheaper, I don't know. But yeah, so insurance clauses, they do not apply in this case.
And I would add too that many of these assisted suicide laws, including the one being proposed in Minnesota, the person that the family member that could be the witness could also be a person that could be inheriting the person's estate. So there certainly could be a conflict of interest there as well.
Mm-hmm.
Please, if you have additional questions, feel free to enter them in the Q&A. We've been getting some great questions. We have a couple minutes left, so we can answer a few more questions. We have a question here about coercion and capacity assessment. I know you talked briefly about that in your presentation. And in many of these laws, as in the one proposed in Minnesota, it's a very loose definition, I guess I would say, to put it mildly.
Mm-hmm.
And certainly in the context of state institutions, there's even more mitigating factors about how to assess assessment and capacity and coercion in these situations. Do you want to unpack that a little bit more, and how that maybe gets at the whole standard of care, the inversion of the standard of care that we talked about earlier?
Yeah, I'm glad you asked that question. I was hoping to be able to expand on that a little bit in my talk with outside of time limitations. Even separate from state institutions, there are serious problems doing coercion assessments. And the issue is that our medical confidentiality laws are still in place. So if, say, I do capacity assessments all the time as a forensic psychiatry, I assess capacity to stand trial. I know how this happens. I know how it works. You review the medical records, you do an interview with the patient, you talk to anybody who might have relevant information, and you come to an opinion. But because of state medical confidentiality laws, if I were called in to assess a patient for this in Minnesota, I would not be able to talk to anybody with relevant information. I would only be allowed to talk to the people that the patient gave me permission to talk to. So a coerced patient is not going to give you permission to talk to someone who has knowledge of the coercion. So our confidentiality laws really have to be changed to allow a capacity assessor to talk to anybody who might have relevant information, regardless of whether the patient gives you permission or not. Otherwise, you're just not going to be able to detect coercion when it's really happening.
Thank you. Earlier in your presentation, you talked about the civil rights of Institutionalized Persons Act, or CRIPA, which is a really interesting twist on working with persons in an institutionalized setting, and certainly presents a conflict, perhaps a conflict, with these assisted suicide laws. You did outline a potential legal remedy for that. Do you want to expand on how these laws are currently being interpreted, or where you see that going in the next 5 to 10 years as organizations like ours here in Minnesota are proposing more compassionate alternatives to assisted suicide and looking to continue to make sure that assisted suicide doesn't become legal in Minnesota?
Yeah, I think when it comes to state facilities specifically, this is our strongest line of defense, because states can't circumvent federal laws. And there is no appellate court in this country yet that has accepted the proponent's definition of suicide. So the Court of Appeal, New York Supreme Court, and the Court of Appeals in New Mexico, when they heard challenges to their prohibition, both of those highest courts in both of those states accepted a plain dictionary definition of suicide. And that's what they responded to the proponents. This is suicide, regardless of how the statute tries to reframe it. And this is how the federal law tends to look at it too. I mean, there is a federal law in place that prohibits the use of any federal money for assisted suicide. And so that would cover your veterans hospital, that would cover any state facility that receives federal funds. And so we need to circle back and remind people of that.
We have a last question. We're going to wrap up here in a couple of minutes. So I want to thank Dr. Hanson for being part of this webinar series and thank everyone for being on this call. This question relates to financial coercion. And are you aware of any signs of financial coercion in a public or private setting that would somehow influence access to assisted suicide? Do you see that where you are, or do you see that in other settings? I certainly have heard about it in the context of insurance companies. I don't know if you'd like to talk about that piece as well too.
Sure, there certainly have been some well-publicized cases where insurance companies have refused to pay for treatment, but did express a willingness to pay for lethal medication. When it comes to considering the laws, I can tell you what happened the first year the bill got introduced in Minnesota. So every bill, if it gets far enough along, they will produce what's called a fiscal note, and that will give a history of the law, the implications of the law, and the potential financial impact to the state. And it was so telling that first year because the fiscal impact was potential savings due to earlier deaths. And if there's one thing that legislators pay attention to is how much money is going to cost the state and how much money it's going to save the state. So I can't believe they didn't eye that and take it into consideration.
Well, I misspoke earlier. We do have one more question that I want to get to from our guests. It's a really great question. And we talked about it a little bit earlier regarding capacity. Can you speak to the capacity review process in most assisted suicide laws? It appears these are legal capacity determinations and do not relate to mental competency or psychological competency.
Exactly right. So, and I was asked this question in committee during the first year the bill was introduced, the difference between capacity and competence. So capacity is mental abilities that a mental health professional assesses, whether they possess or don't possess decision-making capacity. Competence is a legal decision. There is no requirement for any legal assessment of capacity in these laws. And that's problematic. So if you do an assessment, you assess that the person has been coerced, or if you happen to be treating someone who gets a lethal prescription by mistake and you know they lack capacity, you have no legal avenue to deal with that. You can't challenge it. That prescription becomes the person's property. You can't take away their property because that's theft, okay? Now, ironically, if that were a gun, in Maryland law and many states now, they have extreme risk protection orders. So if someone has a dangerous object they're going to kill themselves with, you can go to court, you can have their gun confiscated temporarily. There is no such thing as an extreme risk protective order for lethal medication. Once they've got it, it's there and you can't take it away.
Thank you, Dr. Hanson. A really insightful presentation. Thank you for being a partner with the Minnesota Alliance for Ethical Healthcare and all of the advocacy and research work you're doing in your own practice. I want to thank everyone that has joined this webinar. Like I said earlier, it will be available on the Alliance YouTube channel to view. And as I said in the beginning, if there are organizations in your network that are interested in what we are working on at the Alliance and what we talked about today, you can go to ethicalcaremn.org/join us, and you can have partners join our great work. Thank you, Dr. Hanson, and thank you everyone for joining. We'll see you next time.
Thank you.